Picture a checking account with $84,000 sitting in it. The man who opened it is gone. His daughter has the certified death certificate in her hand. She has the debit card. She knows the password. She knows exactly what her father wanted because he told her 100 times, and the bank still tells her no. Nobody committed fraud here. Nobody contested a will. One line on one form was left blank, and that blank line just handed her family to a courthouse. Here is the part almost nobody understands until it is too late. Your will does not control your bank account. Your title controls it. Your beneficiary form controls it. If your account is titled in your name alone and the beneficiary line is empty, that money does not follow your instructions. It goes to a judge, and the judge follows a statute. You can have the most beautifully drafted will in your state, sitting in a fireproof safe, notarized, witnessed, perfect. It does not matter. The bank never got the memo, and the bank does not read wills. And this is not a rare problem. It is the default setting for most of the country. 56% of American adults have no estate planning documents at all. No will, no trust, no medical power of attorney, no financial power of attorney. That number has barely moved in a year. Will ownership actually fell 5 points in 12 months, dropping from 31% to 26%. 42% of Americans say they would not know what to do if a family member died today. And among people with no documents at all, that climbs to 56%. So what actually happens to that $84,000? It waits. Probate in the United States runs 9 to 24 months on average. One national study put the typical case at 20 months and found that only 2% of Americans guess anywhere close to that number. Texas and Florida often close in 6 to 12 months. California and New York routinely run 18 to 24 months or longer. And it costs. Total probate expense typically lands between 3 and 7% of the gross estate. On a $500,000 estate, that is $15,000 to $35,000. In California, the statutory fee schedule is 4% of the first $100,000, 3% of the next $100,000, 2% of the next $800,000, and it gets charged twice. Once to the personal representative, once to the attorney. Now let me show you the 5 ways a bank account walks your family into that courtroom. Trigger 1 is the simple one. The account is in your name alone, no beneficiary named, no joint owner. It is a probate asset the moment you die. Trigger 2 is the one that breaks my heart, because the person did everything right and then life happened. You named your son as your payable on death beneficiary. Your son died before you. You were grieving, and updating a bank form was the last thing on earth you were thinking about. In Florida, when no named beneficiary survives the account holder, the funds belong to the estate of the last surviving party. The designation is treated as if it never existed. That account is now a probate asset, exposed to creditor claims, and sitting in the public record. Trigger 3 is the grandparent trap. You put your grandchild's name on the form because you love her and you want her to have something. Florida law lets a natural guardian receive up to $15,000 for a minor, $1 above that, and the court requires a supervised guardian of the property. That means annual accountings, restricted depositories, attorney fees, and a mandatory lump sum payout to that child the day she turns 18. You wanted to help her through college. You may have just handed a teenager a check and a court file. Trigger 4 takes 3 seconds to create. Somebody writes "my estate" on the beneficiary line because it sounds official and it sounds safe. It is neither. Naming your estate routes the money directly into probate by design. You did not avoid the court. You mailed the court an invitation. And Trigger 5 is the cruelest, because these are the people who paid attention. You hired the attorney, you signed the trust, you funded it properly. Then 18 months later, you opened a new savings account at a different bank in your own name and never retitled it. That single account can drag an entire estate into probate. Yes, you have a pour-over will, and yes, it will catch that account eventually. But the pour-over will still requires probate to do its job. The trust did not fail because it was badly drafted. It failed because one account got left outside of it, which is when somebody at the kitchen table says, "Just put my daughter's name on the account." Problem solved. It is not solved. It is relocated, and it comes back bigger. Under California law, the funds left in a joint account at death generally belong to the surviving party. Legally, 100% of that money goes to the child whose name is on it, and that child has no obligation whatsoever to split it with her brothers and sisters. Maybe she does. Maybe she is wonderful. But now her divorce can reach your money, her bankruptcy can reach it. A car accident she causes on a Tuesday afternoon can reach it. And if she withdraws more than the annual gift tax exclusion for her own use, you have gift tax reporting on top of everything else. In 27 states, Medicaid can recover from payable on death funds anyway. Here is what I want you to hear clearly, because I am not telling you these tools are bad. A payable on death designation is free. It takes 10 minutes at a branch, and for a single healthy adult beneficiary who outlives you, it works beautifully. The problem is that it only works in that one narrow scenario scenario. It does nothing if you are alive and incapacitated, because it only activates at death. It offers no conditions, no staging, no protection for a beneficiary who is 19 or in debt or in the middle of the worst year of their life. And in some states, if the estate cannot cover its debts, the personal representative can still come back and collect those funds from the person who already spent them. The fix is not expensive and it is not complicated. It is one afternoon and a legal pad. Write down every single account you own: checking, savings, certificates of deposit, the credit union account you opened in 1994 and forgot about. For each one, name a primary beneficiary and a contingent beneficiary, and ask the bank directly whether they even allow a contingent, because many do not. Sign a durable power of attorney so somebody can act for you while you are still breathing. If you have a trust, retitle those accounts into it and make a standing rule that every new account gets titled correctly on day one. Then review the whole list after every marriage, every divorce, every birth, and every funeral. There is a backstop, and it is worth knowing. Most states offer a small estate affidavit that lets a family collect assets without full probate. California's threshold is $239,700 for deaths on or after April 1st, 2026, after a mandatory 40-day wait. Nationally, those limits swing from $25,000 in some states to well over $180,000 in others. It is a real shortcut, but it is a shortcut you are relying on because something upstream went wrong and it will not cover a house. So go back to that daughter, standing at the teller window with her father's death certificate in her hand. She is not there because her father was careless with money. He was not. He worked, he saved, he built $84,000 one paycheck at a time, and he wanted her to have it. She is standing there because of one empty box on a form that took 90 seconds to fix and never got fixed. Your accounts are already making this decision right now, today. The only question is whether you made it on purpose or left it to a statute and a stranger in a robe. Check the box. It costs you an afternoon. Leaving it blank cost your family a year and a half. If this was helpful, subscribe to the channel and like the video. There's a lot more coming.